Today's hearing turned into what Senator John Kennedy jokingly called an entrance exam. In his signature rapid-fire style, Kennedy put judicial nominees on the spot with tough legal questions, ranging from civil rights and constitutional amendments to class actions and injunctions. What followed was a masterclass in constitutional law, sprinkled with sharp humor and serious testing of legal knowledge.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy
Let's
to
just
go
start in the
first.
middle and we'll work to the end. Tell me, Mr. Also?
Orso, yes. Thank you,
Orso, I'm
Senator.
sorry. I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
What if the employer said, my customers won't like it? Is that a justification?
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work
small business owner said, it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon. David
Bragdon.
Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe it's
It's going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Okay. Do you know?
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Who knows the answer? What's turning your
This
mic
is
on for me,
Judge Rodriguez, and so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this, so supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question, and so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets kicked, and there's only state law claims, does the court exercise jurisdiction otherwise over those state law claims? And there was a recent Supreme Court decision on this that basically said that the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay. We go back to Mr. Rousseau. How do you amend the Constitution?
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough. Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction, and how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You look
I
at
think
the same
that
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a preliminary injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
in
so,
a permanent injunction, you're asking, has the party succeeded on the merits?
correct.
Right?
My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What are they, and what are the elements of you have to prove?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors.
I didn't realize I'd gone this far over. I'm sorry.
This concludes the entrance exam. Now we'll thank you, Senator Kennedy.
I really apologize. I didn't mean to go this far.
Thank you, Senator Kennedy. I appreciate you asking the question. Senator Durbin.
Kennedy started with a sharp hypothetical. He imagined a small business firing an employee for showing up in a burqa, then asked the nominee to apply Title VII of the Civil Rights Act. The nominee explained that Title VII prohibits employment discrimination on the basis of religion, race, color, sex, and national origin. Kennedy pressed further. Could customer preference justify the firing? The answer, no. But if safety was a concern, like the burqa catching in machinery, that could be a valid consideration. Kennedy pushed the nominees to distinguish between genuine safety issues and thin excuses for discrimination. Next, Kennedy asked about supplemental jurisdiction. One nominee stumbled, struggling to recall the specifics. A magistrate judge then stepped in to clarify. Supplemental jurisdiction allows federal courts to hear state claims connected to a federal case. But a recent Supreme Court ruling emphasized that if all federal claims are dismissed, the court may lose jurisdiction over the remaining state issues. Kennedy's grilling underscored how procedural details can shape the outcome of entire cases. Shifting gears, Kennedy tested the panel on constitutional amendments. A nominee correctly cited Article 5, explaining that amendments require approval from 2/3 of Congress or 2/3 of the states. Kennedy's line of questioning showed how even foundational constitutional processes must be second nature to those seeking the bench. Kennedy then challenged nominees on the difference between preliminary and permanent injunctions. A preliminary injunction requires proof of irreparable harm and likelihood of success on the merits, while a permanent injunction demands actual success on the merits. From there, he moved into Rule 23 and class actions, where plaintiffs must prove numerosity, commonality, typicality, and adequate representation. The questioning highlighted how judges must navigate both high-level constitutional principles and technical civil procedure. If you find this kind of breakdown valuable, make sure you hit that subscribe button right now. Stay updated with the most important moments shaping law and politics in Washington. The hearing ended with Senator Kennedy lightening the mood, calling his interrogation an entrance exam. But beneath the humor was a serious point. Judges need deep legal knowledge, quick reasoning, and clarity under pressure. In less than an hour, Kennedy forced nominees to wrestle with discrimination, constitutional structure, and the fine print of federal rules. And in doing so, he reminded everyone just how demanding the bench truly is.